Hello, everyone. My name is Susie Luckman, and I am a legal director at VWV. I have 16 years' experience advising educational institutions, both in the independent sector and in the academies and maintained sector. I lead a team that we have called the VAT Task Force here at VWV, which is comprised of solicitors, accountants, tax advisors, and school specialists, and we are working with schools to help prepare for the implementation of VAT. In addition to the task force, I work closely with our special schools team, which is headed by Kenji Batchelor and Natalie Wargent, and we provide a one-stop shop to meet the needs of special schools and colleges. As you'll be aware, the budget on the 30th of October contained an announcement of the new policy on VAT for school fees. This policy has far-reaching effect, and the guidance makes it clear it is explicitly intended to include independent special schools and non-maintained special schools in its scope. This means that HMRC will be expecting VAT to be paid on fee income received by special schools from the 1st of January. The time for planning and modelling is therefore over, and we now need to get on with the detail of becoming VAT compliant. I am very grateful to Claire Dora and Nas, who have been tirelessly petitioning HMRC and HM Treasury for clarity on the guidance since July and how this will affect special schools and specialist providers. So we are going to start with that question. Does this apply to you? I will then run through what this means in practice for your setting and, most importantly, what some of the risks are. I will then look at what steps you can be taking to mitigate these risks. Ultimately, VAT compliance starts at the top with effective governance and oversight. And finally, I will cover some of the operational changes that will need to be considered when preparing for VAT. I am aware that the special school sector is comprised of a great range of different schools, provisions and settings. I think it is fair to say that your provisions did not immediately come to mind when politicians were proclaiming that they were ending tax breaks for private schools, and yet here we are. This policy has created a new definition of private school, and this is it here for your attention. I shan't read it out because that would just take a long time, but one significant point significant change since the policy was announced at the end of July relates specifically to non-maintained special schools. Non-maintained special schools are no longer excluded from this policy, and they will need to apply VAT to their fees and apply for VAT registration from the 1st of January. This announcement was made on the 30th of October, and so it has come extremely late in the day for non-maintained special schools. So it's something, VAT registration is something that will need to be actioned as soon as possible to ensure everything is in place for the start of the January term. The fact that school fees are paid by a local authority does not exclude the school from the policy. The guidance explicitly states that local authorities will be able to reclaim VAT through Section 33 of the Value Added Tax Act 1994. This is not therefore a barrier to the VAT policy applying to your school. Let's have a look at VAT itself. VAT law is complex, and it is an area of law that depends heavily on case law to determine the legal precedent. As is clear from this particular policy, the legislation itself tends to be relatively bare when it's published, but is later honed and nuanced and filled out by judgments resulting from cases brought either by HMRC challenging a taxpayer or the other way around. So what do I mean by Jaffa cakes and Pringles on this slide? You may already know that there was a case in the 90s where a VAT tax tribunal was called upon to determine if a Jaffa cake was in fact a cake or a biscuit. The VAT reason for this is that if they were cakes, then they were staple foods and the applicable VAT rate was 0. But if they were chocolate biscuits, then they were luxury items and VAT was applied at the standard rate. After a detailed examination of the facts, the tribunal ruled that they were, in fact, cakes. And Pringles suffered a similar spotlight in 2008 when the High Court determined that they contained so little potato that they were not in fact crisps and therefore exempt from VAT. But the drama continued for Pringles because HMRC challenged this decision, and the case ended up in the Court of Appeal, where this decision was overturned and Pringles were deemed to be crisps after all. As a result, following the Court of Appeal's decision, the maker of Pringles faced a VAT bill in the tens of millions. However, fortunately for them, they had chosen to continue paying VAT during the appeal process to avoid the risk of an enormous bill in the event the decision did not go their way. Now, the reason I'm talking about Jaffa Cakes and Pringles is to demonstrate how the application of VAT is no simple matter, and it turns on the facts of each and every case. And case law is vital to understanding these nuances of VAT. But we don't have any case law for VAT in the education sector yet. I see this as leading to three interesting points. Firstly, we have to rely on VAT precedent and definitions from other sectors, which is unsatisfactory and leads to an increased risk of getting it wrong. Secondly, this will be an area of law that will evolve over time as the case law develops, and schools will need to be vigilant in keeping up to date with the legal precedent as it is created. It's also worth noting that the case law will develop from education providers being challenged by HMRC on the way they have applied VAT, and the outcome of that case will determine the way the legislation is applied in the future. It may well be that in the future we refer to the infamous case of HMRC and a well-known school for how we assess the VAT liability for example, school lunches. This is important because one of the main features of VAT is that it is a self-assessed tax. Meaning that it is up to you to make decisions over how you apply VAT, whether your services are a single or multiple supply, or whether you offer any exempt services. Some of these decisions may be relatively straightforward, while others, as I will explain in a moment, may be Jaffa Cake situations and require you to take a calculated risk-based decision using your risk management tools. And all of this is in the knowledge that some education providers may be challenged on their decisions and will become the basis of future case law and legal precedent. The main risk of getting it wrong is underreporting the VAT owed to HMRC, and this can happen in two ways. You can fail to add VAT to supplies that you make, i.e. you don't collect the appropriate amount of VAT on your fees, or you can reclaim more VAT than you are rightfully allowed to reclaim because you've added VAT to a supply that is exempt or outside of the scope of VAT or zero rated. In the event that a school underreports the VAT that is owed, they will have a direct liability to pay such underreported tax to HMRC immediately. In addition, that there may be interest that may have accrued on that amount, and there may be penalties from HMRC depending on the case. The last point on this slide is a quick nod to the fact that education providers will also be impacted by some of the other announcements made in the budget, including the employers' national insurance changes and the rise in the national minimum wage. At a time where there will be increased financial pressures on schools and providers, it's important to do all we can to minimise the risk of an unexpected VAT bill and avoid the sort of tax bill that the makers of Pringles might have faced. So, we don't have any case law at the moment, but what do we know about VAT and education? We should start with single supply. If a school offers one main dominant supply and all the other service elements provided are ancillary or provided for the better enjoyment of the dominant element, those services will be treated as one supply and will be subject to the VAT treatment of that main dominant supply. The alternative is where a provider does in fact supply separate services, and each supply will be subject to its own VAT treatment. That doesn't mean that those VAT treatments will necessarily be different to each other, but it's an acknowledgement that the supplies are factually separate to each other. The more recent HMRC guidance has directed schools towards these existing VAT principles. And for some providers, this may be encouraging news, because if on the facts all the services that you offer are ancillary or for the better enjoyment of education by a private school, then it may be appropriate to add VAT to all the services that you offer as one complex single supply, which would simplify the calculations that you have to make and your VAT return. However, there is no one simple rule for determining a single supply. Each case will turn on its own facts, so schools will need to carefully consider all of the variables and diligently analyse all of its income to assign the appropriate VAT treatment. Now, thankfully, there is an abundance of case law to help guide us in determining single or multiple supplies. And for schools, they might include these questions. These are in no particular order, as there is no hierarchy to consider when looking at these factors. Each school will need to make evidence-based decisions on each of the elements of their supply, and then on the balance of probabilities come to a conclusion. This uncertainty leads to risk. There may also, depending on your provision, be reason to examine whether the education that your school is providing is in fact the dominant supply, or whether welfare and care is actually the dominant element and the education provided is ancillary to that. In that situation, the whole supply could potentially be exempt, and that's the sort of situation where we would recommend you take professional advice. Leading on from single and multiple supplies is the question of exempt supplies. The guidance published by the Treasury states that goods and services that are closely related to education, such as school meals, transport, books, and stationery, are integral to accessing education and will remain exempt from VAT. Well, now, given that I've just been talking about single supplies, where all component elements of a service may be swept up into one VAT treatment, this seems like a contradiction and confusing. And that's true. It's another example of how the VAT treatment of the supplies you are offering will turn on the facts of each situation. One school may consider all of its services are bundled up in a single supply, but a neighbouring school that may outwardly appear very similar may consider it provides separate supplies of school lunch and transport to and from school, as these are offered by staff with different qualifications to teaching. Parents have to opt into these services, or they appear separately on the invoice. In these situations, those services could be separate supplies, and they could also be closely related supplies and therefore exempt from VAT. Providing exempt supplies leads to being a partially exempt business. This means that your fees would include a mixture of services where some attracted VAT but not all. You would therefore need to undertake a partial exemption calculation when reporting your VAT and reclaiming VAT on your quarterly return. And this impacts your ability to reclaim input VAT on your costs. I'll talk more about this in a minute, but schools should take care not to assume that their services will automatically fall under the single supply rules. And you should still undertake in the next few weeks an analysis of all of your income. Part of this analysis will be to assign the appropriate VAT treatment to each and every source of your income to discover if you supply exempt services and the true nature of all your supplies. So this sounds like a lot of work. What can we do to ensure that we are compliant for the 1st of January? The easiest place to start is effective governance and oversight. For directors or governors or proprietors, this is twofold. Has VAT compliance been added to your strategic decision-making process? Does your future strategy now involve VAT implications and risks for your provision? Additionally, it's likely that governors and directors will be asking themselves, how do I know that we are compliant? What are the headline areas that we need to be addressing? And do the relevant people have everything they need to tackle this change in such a short space of time? In essence, do we have a plan? I mentioned risk management tools above, and we consider the easiest way to capture your risk management process is to update your corporate risk register and ensure the risks associated with applying VAT to fees is documented and considered formally. Another easily identifiable step is to ensure that everyone is clear who has authority to make unilateral decisions on VAT or where board approval may be required. Do you have a clear scheme of financial delegation for decisions around VAT? Is the application of VAT actually on your scheme? Alongside this, are proper decision-making protocols clear and being followed? For example, is there a record of the clear commercial justification for a decision, or is the decision in line with professional advice you've received? Is all of this being minuted? When HMRC carry out their visits and inspections at your school and they only give you 7 days notice, is it going to be easy to access the commercial reason for a decision which may have ultimately had an impact on the school's overall tax liability? We would suggest, for example, that decisions around single or multiple supply are presented to the board in a formal paper for approval. As with any new system or process, we recommend an ongoing system of monitoring and review. There is going to be a lot of work now, and VAT is going to occupy a considerable amount of time until we all get used to it. But even once these policies are embedded, directors and managers would be wise to have periodical internal or external review of them to ensure that these procedures are adequate and appropriately in place. I'm very quickly going to run through some of the operational issues that need to be addressed in order to be ready for the 1st of January. VAT registration. If this policy applies to you, and it's likely that it does, you will need a VAT number for your invoice to send to local authorities in order for them to be able to process the Section 33 refund. If they can't process the Section 33 refund, they're unlikely to pay your fees. At the moment, I understand that there is a 3-week processing time at HMRC, so if you have not already registered for VAT, this is something that ought to be actioned immediately. Secondly, making tax digital software is software that HMRC requires in order to engage with their system. You should check that your software is MTD compliant at the first opportunity. Analysis of income and expenditure. I briefly touched on this a minute ago when talking about single and multiple supplies. Each line of your income and expenditure, we recommend you print off a trial balance and go through it line by line. Each line will need to be analysed in order to assign it the correct VAT code. This is true for income so that you can work out what on your invoice needs to have VAT applied to it, but also for expenditure when it comes to reclaiming VAT on your purchases and expenses. Being VAT registered also means that you can reclaim some of the VAT on capital items purchased pre-registration. There are a number of criteria on this, and it is tapered, but this is also something that you should be looking into. And finally, if you are only just registering for VAT, you can reclaim VAT on goods and services that you purchased before you registered, if you are still using those goods and services in your taxable business. For goods, you can look back 4 years. For services, it's 6 months. And this reclaim has to go into your first VAT return. So it's also something that needs to be actioned immediately. If you haven't already been to the HMRC website, it's worth a look to go and become acquainted with it. You can register for VAT online services and explore the community forums. There are also a series of webinars that they have published, and it's all free. There are also a series of excellent webinars and articles published by various independent school advisors and associations. If you have access to these, they are a good source of information. And then at VWV, we have a number of resources which I've listed here, such as the plan, which is a step-by-step plan, and the matrix, which is a tool to helping analyse your income. In summary, there is a lot to do now, and most of it will be new. We aim to look at VAT from a school's perspective and provide some food for thought or action points to swiftly implement this as it's necessary for the 1st of January. The first step is effective governance and oversight, and to make sure that you have proper decision-making processes in place. If your delegation isn't clear, this is something that you can have a look at, or at least supervising retrospectively. You need to make sure that your risk management framework and tools have been updated to include VAT in them, and that all of the above is enshrined in policy, procedure, and training. And that all of this is then reviewed as the law changes. It's likely that your finance staff are feeling the pressure right now. So in terms of resource and training, this is something else that we suggest schools take a look at immediately. And then those are my contact details. Those are also the contact details of my colleague, Nikki Miller. Nikki is proudly an accountant, not a solicitor, and a schools advisor and ex-bursar. So between us, we aim to be able to answer the questions, or at least point you in the right direction. I hope this has been useful, and thank you ever so much for listening.